What can you do when someone uses your content without your permission? Hi, I'm attorney Gordon Firemark, and this is Asked and Answered, where I answer your entertainment law questions to help you take your career and business to the next level. So this is one of the more common questions I get asked, and it's universal. People at all levels of experience in the industry eventually encounter a situation where someone is using their material without permission. And when that happens, it's hard to know just what to do about it. There are several approaches that you can take, and I'm going to present them in order here from sort of least to most adversarial. So you're going about your business and you discover someone has lifted some of your stuff. Whatever kind. Maybe it's an article from your blog or a photo from your website, or maybe it's something more substantial like a script, a book, or a film, or what have you. First thing you have to do is figure out, is it something you really own? Let's make sure we're talking about something that actually can be legally protected. You see, intellectual property only protects certain things. Patent law protects inventions. Trademark law protects brand names. And copyright law protects the original expression of ideas. Not the ideas themselves, and not facts. Those things are not protected at all. Okay, so if you are an inventor and you find that someone has infringed on one of your patents, you need to contact a patent lawyer, and fast. There's not likely to be much self-help that you can do in this situation, and you can actually hurt your case if you try to work things out without proper counsel. Now, if you're dealing with a brand name, a trademark, well, we have to make sure that the alleged infringer is in fact creating a likelihood of confusion in the consumer's minds. That means that if you're selling shoes and the other outfit is selling chewing gum, well, then it's probably not an infringement of trademark. But if you're in the same class of goods or services, or one that's very closely related or likely to be the next place you take your business, then it probably is an infringement. First approach here? Well, you might succeed with a casual approach, either a call or a letter to the owner of the other company, alerting them to your priority rights and asking them to stop. But unless they immediately do so, you're going to want to consult an attorney. Now, if you're dealing with copyright protected material, how you approach it is going to depend somewhat on the medium in question. If the infringement is happening online, using a digital information service like a website like YouTube or what have you, then you might be able to get the service to take down the offending material using the DMCA Takedown Notice procedure. The DMCA stands for Digital Millennium Copyright Act, and it provides for so-called safe harbor for services that carry user-generated content if they have a procedure for taking down infringing content their users post. If they have that procedure in place and they've jumped through a few other hoops, then you can't sue them. And as long as they comply with that process, they're safe. That's the safe harbor. The process is simple. You send them a properly worded DMCA takedown notice. Sometimes this can even be done using an online form that they've set up that provides the details about the infringing material. And then that service provider takes the appropriate action. And that's the end of it. Unless the user who posted it files a counter notice. In that case, the material gets put back up and you are free to choose to sue them for copyright infringement if you think that makes sense. But if the infringement isn't happening online, like if it's a print or a film or a recording or a so-called old media of some sort, then you're going to have three choices. Step one is ask the infringer to stop. Number two is send a written cease and desist demand. And number three is file a lawsuit. There's that escalating adversarial nature, as I was talking about. Now, I usually recommend following this approach in sequence. Sometimes people infringe copyright inadvertently or just ignorantly. They didn't know they needed permission. So when a rights holder calls or writes them and politely asks them to stop the infringement, they do. But if you skip the more flies with honey kind of an approach and jump right to the cease and desist demand, which is sometimes very appropriate, you are more likely to get some pushback in response. That just escalates things and winds up costing everybody legal fees. Next up is the cease and desist demand. This is really just a strongly worded lawyer letter, or a nastygram, as some folks like to call them. In it, it declares who the rightful owner is, what's being infringed and how, and it presents a demand for the infringer to take various steps. I've seen steps as simple as stop what you're doing and apologize, and as complicated as requiring the infringer to not only stop, but also pay a fee, present accounting records for review, notify the customers, recall offending goods, and so on. The more complex and, let's face it, expensive those demands are to comply with, the less likely they'll do so quickly and quietly, even when their lawyers advise them that that's what they should do. Remember, I've characterized this as a demand. Now, some people mistakenly refer to this as a cease and desist order, but unless something comes from a judge, it's really better viewed as a formal request for compliance. Without that judge and a hearing and a ruling, it just doesn't carry the full force and weight of law. So, if they resist or refuse or just drag their feet, the next step is to file a lawsuit against the infringer. Now remember, suing someone means you've got to prove some elements. For copyright infringement, you have to prove the following things. 1, that you own a valid copyright. 2, that the defendant copied the work in question. And that means you have to prove that there was both access, that you either showed it or sent it or gave it to them to look at, or they could have found it online and likely did. So you prove access, and then you have to prove substantial similarity. Now, I'm not talking about a little bit of similarity. Substantially similar means that the similarities have to be pretty significant. And there's sort of this sliding scale. If the defendant had lots of access, then you don't have to prove as much similarity. And if the defendant had very little access over here, then you have to prove lots of similarity in order to make the case for copying. Once you've done that, you're left with proving that you sustained damages. That is, unless you've registered your copyrights within 3 months after publication of the work, so you can claim those statutory damages. Oh yeah, and you've got to be prepared to prove why this particular infringement isn't a fair use. But that's an explainer for another day. So there you have it. If someone is using your content without your permission, here are the steps. Make sure that what you're claiming is yours really is yours and is protected under the law. Ask nicely if there's any chance that doing so is going to get you your desired result. If it's an online infringement, use the DMCA Takedown Notice procedure. And finally, have a lawyer send a cease and desist demand. And then, if that doesn't work, file a lawsuit. Unfortunately, if you own a piece of intellectual property and it gets infringed, you pretty much have to do something about it. Otherwise, there's a doctrine of law that can actually strip you of your rights. So don't sit on your hands. If you don't protect your stuff, the law won't either. Well, that's it for this Ask and Answered Explainer. If you have a question you'd like to see answered here, please visit firemark.com/questions. And I'll see you again soon.